Hold up, grab my soda cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape paint. We ain't talking vapes or the color of drapes. Or a gorilla in a cape is the good shit. Just one hit, you so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation, with gross castration, skewed citations, by your intimations. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation, with gross castration, in skewed citations, by your intimations. I'm a truth in rotation, you're a cheap imitation. Dark set hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in the cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over this bit, non-bit.
Thank you for joining us at Personality Inventory Mockumentary Productions.
And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Coming at you today because the Iowa Office of Civil Rights contacted me this morning for a phone interview. They're taking up the case and going to investigate, despite what's going on in the courts right now. So that's a good indicator that they believe that there is a valid civil rights claim going on, and are willing to take action, which I believe I discussed before, that generally they only take pretty much absolute cases. And what we're talking about when we say absolute, this is what I've been talking about with the presumption of retaliation, in the fact that the landlord negated to give a strict statutory mandatory notice of a 7-day notice to cure for the upstairs tenant upon our good faith complaint. So we're going to take a look at that real quick, and that is Iowa Code 562A15. Okay, this is landlord to maintain fit premises. The landlord shall comply with requirements of applicable building and housing codes materially affecting health and safety. And when it comes to my companion, it does affect her health and safety if she doesn't have that quiet enjoyment of a habitable space, which is one of their maintenance issues. Let's see here. Okay. Under subsection B, part 2, the landlord and tenant of a single-family residence may agree in writing that the tenant perform the landlord's duties specified in subsection 1, paragraph A, subparagraphs 5 and 6, and also specified repairs, maintenance tasks, alterations, and remodeling, but only if the transaction is entered into in good faith. Okay? This is where any contract you sign with the implied intent of good faith. Okay? If the agreement of the parties is entered into in good faith and is set forth in a separate writing, signed by the parties and supported by adequate consideration. Supported by adequate consideration. In good faith, we as tenants have paid monthly rent every month for approximately 6+ years and have never been late. Okay? Goes on to say, if the agreement does not diminish or affect the obligation of the landlord to other tenants in the premises. If the agreement does not diminish or affect the obligation of the landlord to other tenants in the premises. The obligation of the landlord is what's being questioned here, because we gave them a good faith notice of the noise issue. At that point, they are required by law to provide a 7-day notice to cure. The next one is Iowa Code 562A.36. And this is the Uniform Residential Landlord and Tenant law here in Iowa. Retaliatory conduct prohibited. Except as provided in this section, a landlord may not retaliate by increasing rent or decreasing services, or by bringing in or threatening to bring in action for possession after the tenant has complained to a governmental agency charged with responsibility for enforcement of a building or housing code of a violation applicable to premises materially affecting health or safety. B, the tenant has complained to the landlord of a violation under section 562A.15. We gave them that good faith complaint of a noise issue. And again, under the maintenance, landlord and tenant, repairs, maintenance tasks, maintaining a quiet and peaceful enjoyment of the habitation includes a noise complaint from a tenant. If the agreement does not diminish or affect the obligation of the landlord to other tenants in the premises. The obligation of the landlord to the other tenant upstairs was to give him a 7-day notice to cure, otherwise he would be evicted. That is the obligation of the landlord upon our good faith complaint. Okay? So let's go on. I got to change my screen here, so bear with me. Okay, this is the argument. And the argument for the court for the civil rights violation by the tenant or by the landlord. So they're both misapplying this error. The landlord is not recognizing that there is a presumption of retaliation because she did not follow the strict statutory duty. And this is seen in Bloomquist versus Hillview. I'll pull that up here. But we'll go through this first. Error in applying Iowa Code 562A.36, which is the retaliation one we just looked at. It says, note, tenant gave a good faith notice of noise issue under Iowa Code 562A.15, which is acknowledged by Listy Wickham. She acknowledged this in court that she did receive a complaint on this. She acknowledged that she did know that there was an ongoing situation between us and the upstairs neighbor. She did admit judicially on the record as well that she did not know that she was supposed to give a 7-day notice to cure. And she did also admit that she did not give a 7-day notice to cure. The presumption of retaliation, which we get from the Hillview standard, again, I'll pull that up. Under Iowa law, specifically Iowa Code 562A.36, a landlord may not retaliate by bringing an action for possession after a tenant has complained to a governmental agency or the landlord, in this case, the property manager, about the maintenance issue or habitability issues. In Hillview Associates versus Bloomquist, the Iowa Supreme Court established that if an FED, this is a forcible entry and detainer, action, is brought within 6 months of a tenant's good faith complaint, a rebuttable presumption of retaliation is created. A rebuttable presumption of retaliation is created. In this case, it cannot be rebutted because the presumption was brought about by the landlord or the manager, property manager herself. She admitted she did not give a 7-day notice. She admitted she did not know that she was supposed to. And it doesn't matter. Again, to me, I will admit that it may not have been retaliation in that sense, but Iowa law says that there's a rebuttable presumption of retaliation. And if she wants to rebut it appropriately, I would allow that. But the only rebuttal that could be had is the fact that she did not know. And therefore it wasn't intended as retaliation, but rather as a matter of ignorance of the law. This is still no excuse. Okay? So the burden of proof then shifts to the landlord to prove a non-retaliatory reason for the eviction. This is where the court comes in. The court had a strict statutory duty to place that rebuttable presumption of retaliation on the record. In other words, the burden of proof shifts to the plaintiff to now prove that through rebuttal that they were not retaliating. That is what I am accepting of. If she can get on the stand and prove that she wasn't retaliating, again, the only proof she would have was her admittance on the record already that she was ignorant of the law. But that is still no excuse. She still caused a civil rights violation by not giving the 7-day notice to cure. That is a right to cure. You have a right to cure in contracts. She did not provide that. And like it says, the burden of proof then shifts to the landlord to prove that. Judicial admission of statutory neglect. The appellant asserts that the district court erred by ignoring the property manager's judicial admission. The property manager testified on record to the following. Notice received. The manager acknowledged receipt of the appellant's formal noise complaints regarding other tenants. It did not have to be in any form. It was merely an acknowledgement that we had a noise complaint and then failure to act. The manager admitted to not addressing these complaints in accordance with the landlord's duty to maintain a fit premise and ensure the quiet enjoyment of the property. The manager admitted that instead of mitigating the noise issue, they allowed the situation to escalate directly into an FED filing. Legal conclusion: by failing to address the noise complaint, a statutory duty, and subsequently filing for eviction, the landlord's actions satisfy the elements of retaliation. The FED was not a response to a legitimate lease violation, but a proxy to silence a tenant who was demanding their rights under the Iowa Uniform Residential Landlord and Tenant Act. Note, because the property manager admitted to receiving the notice and failing to act, the presumption of retaliation remains unrebutted. There is no record of the rebuttable presumption. So it remains a presumption of retaliation, and there's been no rebuttal. This is handed down in Bloomquist versus Hillview. The lower court's failure to apply this presumption constitutes a reversible error in law. See, it's the lower court's failure to apply this presumption. They're the ones that have the duty to apply the presumption. The next one is the judicial admissions. Essentially, the plaintiff filed a claim upon which relief cannot be granted. The plaintiff entered with unclean hands. Objection. Video entered as hearsay and out of context as clear and present danger without first addressing the good faith notice noise complaint given by the defendants and appellants. And this is transcripts page 2, line 25 to transcripts page 4, line 13. There's a whole section there about where they entered in a video from the upstairs tenant claiming that I was a clear and present danger a full month after the whole thing started, 2 weeks after we complained to the landlord or to the manager, and they did nothing. 2 weeks later, then the upstairs tenant gives them a video, and now they want to act. Now they want to go through and evict somebody on a good faith complaint. Right? Listy Wickham, the property manager that we're talking about, the one that's directly involved in this, acknowledged being given good faith notice of defendant's noise complaint. Transcripts page 4, lines 24 and to transcripts page 5, line 2. So there's, I think there's 25 lines a page. So there's like 3 or 4 lines there. Transcripts page 6, lines 16 through 23. Transcripts page 7, lines 13 through 16. So 3 times on the record, she's admitted that we gave them a good faith complaint. Listy Wickham admitted to not giving a 7-day notice to cure, but just a general notice to all tenants by text. So a 7-day notice to cure is a written on paper and either directly handed to them or sent to them through the mail. It's a 7-day notice to cure, a written 7-day notice to cure, but just a general notice to all tenants by text. Transcripts page 5, lines 3 through 7. Listy Wickham admitted to not knowing she is required by statute to give a 7-day notice to cure. Transcripts page 5, lines 7 through 16. Listy Wickham admitted to managing property for 8 years without this knowledge. Transcripts page 5, lines 17 through 19. So we have a judicial admission on the record of a plaintiff who came to court, a forcible entry and detainer, which is a equitable action. So they came into equity with hands as dirty as my furnace filter. And nobody's sneezing. It's amazing. The tribe says terms of your leasehold is the law. Yes, contract is the law. So in that contract, in good faith, if we give the landlord or the property manager a good faith complaint that the lease is being broken by another tenant, and explain to him how that lease is being broken by that other tenant, aka a noise complaint involving running, jumping, stomping, hollering, screaming, yelling all day long and beyond the 10 p.m. hour. Yeah, we did our part. They failed theirs and they admitted it on the record. Yes, make the affirmative allegation first, then they must rebut it or it stands. And this is what they're failing to do. The court themselves are failing to act on their duty of laying that presumption of retaliation. That's something that should have been handed down right there and then on the spot. Instead, they voided the 3-day summary, went to they diverted from adjudication and took it under advisement. Now, in a forcible entry and detainer, that's a 3-day turnover. They're supposed to resolve it in 3 days. She said she was taking it under advisement and she would get back to us in about a week. In a week, the week mark, she did not get back to us. The 1st of February. On the 2nd of February, I was doing a video, on the 1st of February, I was doing a video, and we got notice of the place we're at now that it was open and we could come have it. So on the 2nd of February, we moved. On the 3rd of February, a full 9 days later, the plaintiff went in and requested a voluntary dismissal. Even though by Iowa rules, once the hearing was had, they are barred from entering a voluntary dismissal without consent of the court. So the court turned around and consented to a voluntary dismissal of a plaintiff who came to court with dirty hands and allowed them to state their dirty hands on the record, and then evaded their strict statutory duty to lay the presumption of retaliation. So now, like I said, we've got the Iowa Office of Civil Rights involved. And if they deem themselves through their investigation that the courts have also violated our rights, then the claim goes against the court now as well. All the evidence is there. It's all part of the record. They're the ones making this record. They're the ones showing that they don't operate under the law like they're supposed to. So think about this stuff. Yes, enjoyment is one of the property rights of leasehold. Actually, in American jurisprudence, the very definition of property includes the word enjoyment. And I believe, don't quote me precisely, but I believe it says something to the effect, and I think I'm pretty close, that property is the right of possession and use for one's enjoyment and benefit. That's the definition of property. See, most people don't understand the definition of property. They think it's a material thing. No, it's intangible. That is what your right is your property. People think they have rights. No, you have a responsibility. You have a responsibility to protect what's your own. If you don't, other people will take it, no matter what it is. They will take your peaceful enjoyment. They will take your property, your possessions. They will move you from your possessed area and make you go to somewhere else to possess an area. Yes, property rights are a bundle of sticks. If you go on, you think about this, and they've done this. We can look up all the American jurisprudence words and everything and find out where they place them. But imperatively, it is important to understand enjoyment, exclusion, and disposal. These elements is to enjoy that area, to exclude things or people out of that area. And when you exclude things, it's disposal. It's dispositioning. That's what disposal means. You disposition it. So when you think you're getting rid of the garbage, you're not. You're just dispositioning it. You're removing it, excluding it from your area because you don't enjoy the stink. You don't enjoy all the dust flying up in the air making you sneeze. That's why you replace the furnace filter once a month. Not whenever you fucking feel like it. Rights and interest. 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 In terrestrial establishment. Not in your spiritual establishment. In your terrestrial establishment. This is why people cling on to the material world. So think about this stuff, folks. And remember, welcome to the Short Bus Podcast. There's a link pinned at the top of the comments. That is P.I.G.S.C.U.N.T.S. I only need 4 more subs. I'm going to cut this video, and I'm going to come back shortly with another sub drive video for P.I.G.S.C.U.N.T.S to start our new show. Welcome to Short Bus Podcast TV, where we're going to start doing debates, hopefully with a level of etiquette. But as we all know, bullshit comes along with these panels, so we'll have to deal with them. Hopefully, we have developed ways to deal with them to enjoy chat participation and panelist behavior changes. We want people to grow in this education. This is not about drama. This is about education. A good panel should have a viewership that learns, because the First Amendment is imperatively important to myself as a singular individual, that I get to express myself. But the imperative, or the exponential imperative, is that other people have a right to know. And there are a lot more people out there that have a right to know about how this stuff works than just my right to express it. So keep tuning in, keep hitting those buttons, bring more people to the platform. Everybody needs a good education. I too was indoctrinated just like you. But the only way we get that education is by being autodidactic. Quit listening to everybody else and do your research. Don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. And when you research both sides of the track. And when you do your research and you do it on both sides of the track, continue to follow up on that research, because over time, things change. So when you keep up to date on things, like the distillation laws, I found out recently Iowa changed its distillation laws. In December, you can no longer distill your own liquor here in Iowa. However, keeping up with the research, I have also found out that at the federal level, they're getting ready to just tear that all apart and just say that you can. It's the first step to the legalization of cannabis, is to completely get rid of the Prohibition era laws. Period. So think about that. Hit that like button, hit the share button, hit the subscribe button, and also go over to Heckle Bus Rides. The link is pinned to the top of the chat. Give me some subs over there. I only need 4 more to go live, and then we can start doing these panels. In the meantime, you know me. I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. And that part's on you. So may God bless you. And let me get my screen share up on the outro. You guys have a wonderful day. We'll see you here shortly.
Hold up, grab my soda cause I told you I'm colder than hell. I ain't buying what you sell, it don't ring my bell. Unless it's got the smell, you know, like grape paint. We ain't talking vapes or the color of drapes, or a gorilla in a cape. It's the good shit, just one hit. You so lit, you fall into a bit, non-bit. What's fucking funny is you're a monkey, a high school flunky, hero and junkie, obliteration of the carnation with gross castration, skewed citations by your intimation. Get real, young man, there's only one stand. You can't stand a suntan, how you gonna live on the land? Obliteration of the carnation with gross castration in skewed citations by your intimations. I'm a truth in rotation, you're a cheap imitation. Dark said hums, 808s make the ground shake. Cold as the grave, every word's a land quake. You're a flicker in a cipher, I'm the flame that won't fade. Step into the night where the shadows are made. What's fucking funny is you're a monkey, a high school flunky, hero and junkie. I'm gonna click another hit of this good shit, and I'm already it, so take over this bit, non-bit.
Thank you for joining us at Personality Inventory Mockumentary Production.